Thanks for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program. We are coming to you live from Washington, D.C. Our webinars are every Wednesday and are provided complimentary. They are recorded and can be downloaded from our website and YouTube channel, which now holds over 300 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for a speaker, we will have more information on the last slide of presentation today. A special thanks to our educational sponsor, the National Veteran Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. And now a little bit about us. We work with the U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. We also have opportunities for your organization to advertise in our newsletter. We now reach over 17,700 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. And now to introduce our speaker, Rose Stern. Welcome, Rose. We're glad to have you here with us today, and I'll turn the floor over to you.
Thank you for your introduction, Copen. I appreciate that. On behalf of the McGuire Woods Law Firm, we hope everyone is staying well and safe during this time of the COVID-19 social distancing. Even though most of us are working from home, my clients are working harder than ever. And in many cases, they're pivoting to work in new or tangential areas or expediting work at the direction of the government customers. Having effective teaming agreements is especially imperative when contractors move to new areas and they have to rely on technical expertise and performance experience of their team members. I've been counseling government contractors for over 20 years. And I've seen a lot of things, and this is a really interesting and difficult time. And I really want to say that I appreciate all the government contractors who are on the line and all the work that you're doing. Next slide. The next slide. Thank you. Slide number 1. So where are we going? I like to start off with a where are we going so everybody follows along and understands what's happening. The topic is teaming agreements and the top 5 pitfalls. So the first thing we're going to do is look at a really general description of what a teaming agreement is, and then we're going to move into the specialization of the teaming agreement as it relates to federal contracting. And then we're going to look at the top 5 pitfalls that I've seen in my practice over the years, the top gotchas, if you will, and then some mitigation strategies to help you avoid those pitfalls. And the very last part, what we're going to do is an overview of the takeaways that you should have gotten from the slide deck. And then if we have time, we're going to run through an actual example. So next slide, number 2. This is the simplest slide we're going to look at, and it's basically a very high-level description of what is a teaming agreement. Well, a teaming agreement is a written document between the parties for the purpose of working together and bidding on a contract for a specified period of time. And that is the highest level definition, and it really applies to any kind of contracting, not just government contracting. The next slide. Pitfall number 1, ignoring the industry. So industries, that first come to mind are federal government contracting, state and local contracting, and commercial contracting. And one thing that I've seen is sometimes contractors move down the road in working on an opportunity, and they don't really particularize the transaction or the agreement depending on whether they're in federal, state, commercial, or other venues. For purposes of the discussion today, we're going to be focusing on federal contracting. However, I want to stress that companies should really take a look at this in the first place because if you ignore specific rules of, let's just say, federal government contracting or state and local, there can be severe penalties, including criminal penalties. But on the other hand, if you are putting your proposal team together based on commercial contracting and you apply normal federal rules, you're probably going to be over in price because you're going to be including costs for compliance that aren't really necessary in a commercial marketplace. Next slide. Okay, slide number 4. Like I said, we're concentrating on federal contracting today, so we're going to finally hone the general definition that we provided on the second slide. Looking to the Federal Acquisition Regulation, which is what the FAR stands for, 9.601, you'll see the definitions. The regulation envisions 2 kinds of relationships in federal contracting: partnerships or joint ventures, and then the second is prime subcontract relationships. Note that the FAR does not require a written contract, and disputes may arise on verbal agreements alone. Generally, the federal government favors teaming arrangements, acknowledging benefits, especially in the areas of complex research and development and set-aside opportunities. For those of you who want to read more about that, check out FAR 9.602, 603, and then crucial definitions like what is a subcontractor in 9.604. So we're going to launch into our first particular question that I get a lot. I received it basically saying, is it even worth drafting a teaming agreement and negotiating with the contractors? Because I've heard that teaming agreements are largely unenforceable. And the answer is one that most clients don't want to hear. The answer is not black and white. It depends. But the good news here is that the parties themselves, through their negotiations, determine enforceability. And so there is an impact to impact that. There's an opportunity to impact that determination. Sometimes the parties' words, terms, and actions unintentionally impact that determination. So I want to make sure that you understand some of the things that if there's a challenge on enforceability of your agreement, the court would be looking at. Agreement terms at the very high level that are vague or just really amount to an agreement to agree to something in the future is generally not enforceable. Generally, terms are enforceable if they're specific enough to document the agreement between the parties. So to that end, teaming agreements that contain all the essential terms might be legally cognizable as a subcontract. So in other words, what that means is the court may interpret a teaming agreement to act as a subcontract and even enforce those specific terms. So the pendulum swings all the way from the left of unenforceable to the right of being enforceable to potentially more than what the parties anticipated. Cases are very fact-intensive, and parties' actions versus the terms in the agreements may actually create an enforceable agreement. So let's look at an illustration with a recent case. The CGI Federal versus FCI, the Supreme Court of Virginia recently affirmed the lower court's decision to set aside a $12 million verdict for the subcontractor. The parties negotiated a teaming agreement for the joint preparation of a bid to the Department of State, and it was for a visa contract. FCI is a small business, and this was a small business set aside. So FCI was in the position of prime, but it lacked resources to execute the opportunity by itself, so it teamed with CGI, which is a large business. CGI agreed to exclusively bid with FCI. The court found that there was a valid and enforceable contract between the parties' relationship during and through the bidding process. This was because the teaming agreement itself laid out, as I said earlier, with particularity, that's an important term, the rights and obligations associated with the submission of the proposal. And so it basically there was evidence of what the two parties intended the agreement to be. On the other side, though, regarding an obligation of FCI to issue the subcontract, the court found the contractual provisions were not enforceable because they merely set out an agreement to agree or an agreement to negotiate something in the future. So the prime's obligation to issue the subcontract was therefore unenforceable at the end of the day. What's really important for us, or instructive, I guess, is that the court pointed out some terms in the teaming agreement and also the actions of the party that the court relied upon in making its decision. So these are things that you might want to think about when you're crafting your teaming agreement. 4 points in particular are helpful. Number one, During negotiation of the teaming agreement, CGI insisted on receipt of 40% of the work share, and as a result, an actual subcontract statement of work was attached to the teaming agreement. So, this point leans more towards the decision that the obligation did exist and was enforceable for the prime to issue the subcontract on award. However, in the teaming agreement, the parties themselves characterized the statement of work or SAL as subject to final solicitation requirements. And in addition, the agreement required the parties to enter into good faith negotiations for a subcontract. And that good faith negotiation was subject to a laundry list of conditions, including regulations, terms of the prime contractor, and prime contract on and on. So the parties referred to the associated subcontract also as a contemplated subcontract, which suggested that it was something that was only contemplated as a possibility for the future. The teaming agreement contained also numerous conditions that had to be satisfied for a subcontract to be negotiated. And the last point is that the agreement stated the teaming agreement would expire 90 days after an award of the contract if awarded to FCI, and here's the linchpin, if the parties could not agree on the terms and conditions of the subcontract. So that was probably the worst condition leaning towards unenforceability. The court also turned to looking at the actions of the parties that would indicate one way or another that they had come to a solid agreement. And the parties renegotiated the stated work share that I talked about earlier, but then they failed to update the teaming agreement with the promises that they were making along the way. So that really kind of indicated that the parties were still in negotiation as to whether there would even be a subcontract. If you're one of those folks who likes to look at cases, another case to watch for is Alabama Aircraft Industries versus Boeing, that included an alleged breach of a non-disclosure agreement that was attached to the teaming agreement. And that's something I want to stress, is that it's always important to have a non-disclosure agreement or sufficient non-disclosure and confidentiality terms in your teaming agreement. That was between those parties for a $1.3 billion Air Force opportunity. In the latest verdict, the court awarded Alabama Aircraft $800,000 for what it found was a violation of the bidding agreement, and another $1.3 million for a violation of the non-disclosure agreement. This case is still ongoing. The reply was just filed on March 20, so that's something that you might want to keep an eye on. So these are all issues you should consider in negotiating your teaming agreements. Most likely, if you're the prime, you're going to want the flexibility in issuing a subcontract after award, but on the other hand, you're also going to want the teaming agreement to be non-binding as to your obligation to issue a subcontract. If you're the subcontractor, the other party, you're going to be incentivized to include particularized terms related to both, number one, the bidding process, and number two, the obligation of an issuance of a subcontract, including any terms that you believe are absolutely essential and necessary. Next slide, number 5. So I wanted to take a little bit of time and talk about, because I believe we have, quite a few small business set-aside contractors on the line, just a brief note about small business set-aside considerations in your solicitation. So in planning your teaming agreement, make sure you analyze the qualifications of the set-aside program that you're bidding towards. And in addition, carefully consider the factors laid out on the slide. Number one, the correct determination of size after considering exceptions like the SBIC exception and mentor-protege exceptions as examples. Affiliation factors considered under the totality of the circumstances test include ownership, management, identity of interest, newly organized concerns, joint venture, franchise and license agreements, and ostensible subcontractor. Also pay particular attention to the minimum percentage of work requirements and the participants' ability to adjust percentages as required by the SBA or otherwise, most notably regulatory requirements. One other thing to keep in mind from a practical standpoint is once you do your analysis, it's a good thing to capture it in writing contemporaneously, which means at the time you actually figure it out, because retaining your analysis related to size compliance will be helpful in defending a potential bid protest that may occur over a year or more after you're preparing to create your bid and all that effort starts. And you may forget by that time what you were even thinking. The primary factors considered by the SBA under the totality of the circumstances test that I laid out there in bullet number 1. In case someone wants to read more about that, you can find it at 13 CFR 121.103. I wanted to talk in particular about the factor of ostensible subcontractor because I get a lot of calls and questions about exactly what that means. So one thing to keep in mind is if the two entities are quote unquote affiliated, that means that the two entity sizes will be combined for purposes of determining eligibility on the proposal. Okay, so ostensible subcontractor. A prime will be considered an affiliate of the sub. As I said, their sizes will then be combined when the sub performs primary and vital requirements of the contract, or when the prime is unusually reliant on the subcontract. Historically, the SBA in cases has looked at 7 factors, it's called the 7-factor test, when trying to determine if a subcontractor is ostensible or if there's over-reliance. Recently, the SBA has found that it may consider all aspects of the contractor-subcontractor relationship, but I'm going to just run through quickly the 7 factors for those of you who are interested. The first one is, who will manage the contract? Number 2, which party possesses the requisite background and expertise to carry out the contract? So in other words, they're looking at, does this small prime contractor overly rely on a large business, for example, or a mid-sized business? Which party chased the contract? What degree of collaboration was there on the bid and proposal effort? Number 5, whether there were discrete tasks to be performed by each, or is there a commingling of personnel and materials such that they appear to be one contractor? 6, the relative amount of work to be performed by each, and last, which party performs the more complex and costly contract functions? Next slide. We made it to pitfall number 2, run afoul of regulatory requirements. So you may be thinking, didn't we just talk about regulatory requirements? But in addition to the regulatory requirement we just talked about, that really goes to the type of federal contract. There's also other regulatory requirements to keep in mind, and they should be carefully analyzed before you actually prepare your proposal, certainly, and through the bidding process. Too often, I come in contact with contractors who only realize that they've underbid their project after award because they failed to take into consideration compliance requirements that they were going to have to stand up. Sometimes these issues only come up when the contractor has been audited or they receive a complaint from an employee or a key TAM action. So in addition to revenue loss, non-compliance may include the possibility of penalties up to and including criminal penalties. Especially if you're teaming with a company that's not well-versed in government contracting, careful consideration of the team's overall compliance picture with the solicitation terms and flow-down requirements is key. Also understand and document agreement on which company holds the particular liability and the team's overall liability. Under certain circumstances, the prime contractor may be liable for the subcontractor's compliance or non-compliance, and a really good example of that is under SCA, the Service Contract Act. I have that there on bullet number 2 in case you want to look it up and find more information. From a timing perspective, it's really important that due diligence is performed on a potential teammate before negotiations of your teaming agreement, especially if you're in the role of the prime contractor. Some really, really basic vetting steps include researching your party's responsibility. So in other words, look on sam.gov and is the party excluded or debarred or suspended? Performance issues. Does the proposed party have any terminations, especially for default or cause? Are there any organizational conflicts of interest? Does the party have the resources to bid and perform? Does the party have a good relationship with the customer? And what is the party's general reputation in the industry? Too often, I find that a client only finds out the answer to these questions when a bid protest is filed, and some of these issues are included in the bid protest, arguing that the winning bidder as a team is not responsible. So you really, if you do that diligence ahead of time, you're going to save yourself a lot of costs and potentially reputational risk. Next slide, number 7. Pitfall number 3, crushed by the balance of power. The bottom line is, even if teaming with a particular partner produces a winning team, it may not be a good business decision if the contract is not profitable. On this slide and the next, I'm not going to read the bullets, but I provided points for you to consider in your analysis of an acceptable risk profile. And the sooner that you run through this analysis, the better in terms of cost savings. The factors suggested are considerations and planning that should not only be looked at before you start negotiating with teaming partners, but I suggest that you set up a periodic review, not only with the folks that are going to be negotiating the contract, but other folks like your senior leaders, perhaps, that can act as a sanity check along the way as you're negotiating. Too often, companies are so enamored with either a potential project or the opportunity to do business with another company that they've been looking at for a long period of time, that they're willing to join a team at all costs. So they execute teaming agreements without reviewing them or even negotiating any of the terms. In some cases, the negotiation takes on a life of its own, and the company leadership completely loses track of the terms, liability, and responsibilities that are accepted. Overall, they lack a clear picture of what the total financial picture looks like until after they receive an award. A potential team member gains leverage in negotiations by virtue of leading the team or holding key personnel, specialized expertise or licenses, past customer project experience, and customer relationships, including past performance. Another thing that gives one side more leverage over another is funding the bid and proposal work. Next slide. This is a continuation of some of the factors suggested for your opportunity analysis, but I wanted to provide emphasis on understanding your company's walkaway position, which is the last bullet on this slide, and stress a system for monitoring the risk share in the negotiations, including your walkaway position. This is probably the most important planning tool, in my view, from looking at these transactions when they go wrong. Remember that CGI case that we talked about a couple slides ago. The court noted that CGI's minimum work share, presumably its original walkaway position, was renegotiated several times through the bidding process and teaming agreement phase, but the parties failed to document any of their agreements in that teaming arrangement. The last food for thought here is understanding bid and proposal costs and planning for recovery, especially if there's a really high investment. So as an example, assume your company cannot bid without a teaming member. What if you spend $150,000 on bid and proposal costs, and then your team member that you can't do without decides to no bid 24 hours before the proposal is due. Is your company okay with that lost investment? And in some cases, you might say yes, because you just wanted to work with this partner and establish a relationship, and you feel confident you're going to have another proposal that you're going to work on with them. But suppose the answer to that is no. As appropriate, you should consider ahead of time whether you want to negotiate particularized or definite terms in your teaming agreement for reimbursement of bid and proposal costs in these kinds of events. And there might be some other events that you could think of as well. So that's just a safe question. Next slide. Pitfall number 4, scalded by the boilerplate. Deciding the terms of the teaming arrangement is highly dependent on the position your company takes, whether you're acting as a prime or you're acting as a sub. I've seen too many cases where the client has been scalded by their very own boilerplate because too often companies have one boilerplate teaming agreement that they send out for every single opportunity. Any boilerplate teaming agreement should be reviewed in light of each project, and the terms should be adjusted prior to sending the draft to the proposed teaming partner. I'll provide 3 examples of terms that vary greatly depending on whether you're acting as the prime or the sub. Number 1, the requirement for the prime to seek best efforts to obtain consent to subcontract, and that's found in FAR 44.2. The agreement that other suitable work will be provided if the government descopes the subcontractor's statement of work, or another subcontract will be issued for equivalent work on a different contract. And number 3, the prime obligations to either number 1, pay timely, or number 2, present the subcontractor's request for modification or REA to the government. So those examples are examples of things or common areas that I see that are highly dependent on which position you're going to play as to how you want to negotiate these kinds of terms in your agreement. Next slide. Living for today. That is a really great saying for a way to live, but it is a pitfall when we're talking about negotiating a teaming agreement. This pitfall speaks to both the parties' individual and the team's need to engage in post-award contingency planning. I find a lot of clients skip this step completely, and it really impacts their capacity to move forward on award. So I've provided a list of things that you can think about and analyze, but I wanted to talk specifically about bullet number 5, which is bid protest planning. A lot of contractors don't want to talk about that, or teams don't want to talk about that because it seems negative, like we just want to assume we're gonna win. But after the fact, that win can be taken away through protest. So I recommend that the parties proactively discuss issues like the team's position on funding, production, defense materials, and potential conflicts of interest once they receive a protest, or if they decide they want to intervene in an action. Time limits on filing and jurisdictional issues associated with bid protests compress the schedule that the parties have to decide these crucial questions. So waiting until a protest occurs to talk about the issues does not allow for the best defense and intervention possible. Next slide. Closing contractor strategic considerations. To summarize the takeaways for today, I have a few bullets. Add analysis and planning to your bid and proposal plan. Number 1, ensure your company proposal and team proposal meet the specific requirements of the industry and the jurisdiction of the opportunity. 2, understand mandatory, regulatory, and other requirements and make sure you include those costs in your proposal. The next bullet, no matter how great an opportunity appears at the onset, analyze and understand the point at which the deal becomes unprofitable and put a plan in place to monitor and possibly walk away if the team or the bidding negotiations fail. Inspect teaming agreement terms, and if you are the drafter, make sure you ensure that the terms are beneficial to your company before you send the draft to your partner. At the very least, ensure the terms are favorable in light of the role that your company is going to be playing as the prime or the sub in that deal. One size does not fit all for templates. Have a plan for individual and team events that are foreseeable, like the loss of a bidding partner, a bid protest, or the process of negotiating a subcontract after award. And a final takeaway, think through the intent of the parties and document the agreements that are intended to be enforceable with particularity. And this will increase the likelihood of enforceability. So, Kolpin, do we have a few more minutes, or are we out of time?
I think we're just about closing up with time.
Okay, so we'll skip our sample then, and I will just say that I'd like to conclude this material, and I hope that you gained a lot of helpful insights on the top 5 common pitfalls. Please feel free to reach out to me with any kinds of questions, and I look forward to talking to you soon. Thanks again.
Thank you, Rose, for a great presentation and sharing your time with us. And thank you to everyone who joined us. The recording will be on our website and YouTube channel within the next 24 hours. Please join us this Friday as we cover each part of the FAR, and join us next Wednesday for more hot topics in federal contracting.